Hi guys, this is a quick video to finish up our chapter on negligence for torts class. In class we got up to talking about res ipsa loquitur, especially involving medical accidents or injuries. We talked about the case where a woman went in for shoulder surgery and suffered a burn to her thigh. So negligence per se is the next section that we were looking at, and remember it deals with accidents that are caused when the defendant has violated a statute. There are some requirements for it. They're listed in your textbook. Those requirements are the defendant violated a statute, that the violation was not excused, the statute was intended to avoid the kind of harm that was suffered, the defendant's violation caused the harm, and the plaintiff was in the class of people, or was one of the types of people that was intended to be protected by the statute. So that's negligence per se. Jurisdictions vary some on whether or not negligence per se can or cannot be refuted by the defendant. States that do allow it to be refuted with evidence put the burden on the defendant to show that his actions were not negligent, even though he violated a statute. But many jurisdictions don't allow the defendant to excuse his behavior at all. So we also look in this chapter at gross negligence, or wanton, willful, or reckless conduct. Those are behaviors that rise above the level of simple negligence. So not just that you weren't acting the way a reasonable person would, but that your behavior was completely unreasonable, that you didn't even exercise the minimum amount of care to try and protect from the harm, let alone a reasonable amount. Okay? So this is a person who doesn't exercise hardly any or no care at all. We talked previously about automobile consent statutes. Remember I told you that there is special protection by statutes in a lot of states that protect a driver or owner of a vehicle from lawsuits for harm that are from just guests in the vehicle. So not someone who's paying for a ride or transportation, but just someone who's riding with you for their own benefit. A friend, could be a family member. Unless the driver was acting recklessly, simple negligence isn't enough. So those auto guest statutes protect a driver from harm or injury suffered by a passenger, so long as the driver's behavior was not reckless. Okay. The next section looks at the causation element for negligence. It splits it into two different parts, cause and fact, or sometimes called factual cause, and proximate cause, sometimes called legal cause. Excuse me. For cause and fact, we're often looking at what's called a but-for test or substantial factor test, which just means that the harm suffered by the plaintiff would not have happened but for the action of the defendant, or the negligent action of the defendant. So bear that in mind. There's an example in your textbook of a employee who's mopping a supermarket floor and leaves a puddle. Another employee who is stocking a display in the aisle and did that negligently. So we have two employees here whose negligent behavior led to a customer slipping in the aisle, falling into the display, and being injured from both. So both the employees there, the one who was mopping and the one who was stocking, both of their actions led to, or were the cause, factual cause of the customer's injuries. Proximate cause, on the other hand, is known as legal cause. And this is where the courts are looking to make sure that there's a sufficient enough connection between the harm that was suffered and the defendant's action. At some point, the courts will cut off liability. Take a look at the example from the construction worker. So you have a construction worker who is on a slanted roof of a building repairing some shingles. Excuse me. He accidentally drops his hammer. It rolls down the roof onto a ladder where other workers are hauling shingles up into the roof. The hammer hits another employee who's on the ladder, knocking him to the ground and injuring him. Homeowner comes out, sees the worker fall from the ladder after being hit by the hammer. Homeowner suffers a heart attack from watching this exciting, awful accident. So his wife comes out, sees her husband having a heart attack. She faints and hits her head on the step. So we have now 3 people injured. The initial negligent action by the worker on the roof was to drop his hammer and not secure it. It injures the first worker on the ladder. Homeowner then has a heart attack. Homeowner's wife then falls and hits her head after fainting. It's clear that the first injured victim, the worker on the ladder, would be covered. However, as we get to the homeowner and the homeowner's wife, we get farther away from the actual cause of the action and from the type of behavior that we would expect, or the type of injury that we would expect from a fallen hammer. Okay? So those last 2 plaintiffs, homeowner and his wife, probably would not meet the burden for the proximate cause, meaning they would not be eligible to sue because they couldn't prove every single element for negligence, which requires showing causation. Your book talks a little bit about the eggshell plaintiff, or the eggshell skull, they call it, which basically requires the defendant to cover the harm caused, regardless of whether the plaintiff is especially fragile or not. So if the plaintiff has some underlying or existing condition, which means that she is harmed more or injured more severely because of the defendant's actions than another plaintiff might be, defendant is responsible for all of the harm caused, even if, like I said, even if the plaintiff is especially fragile. Okay. What else? Your text next takes a look at intervening and superseding causes. An intervening cause is anything that happens or occurs between when the defendant's negligent behavior starts and when the plaintiff's harm is suffered. So it's something that happens in between the behavior and the harm. If an intervening cause is serious enough, then it can be a superseding cause. If it is superseding, then it cuts off the the defendant's extra liability. Okay. There are some examples in your textbook, and there are 4 basic types of intervening causes. They involve forces of God or nature, innocent human forces, intervening negligent human forces, and intervening intentional or criminal human forces. So remember, intervening causes come between the defendant's behavior and the plaintiff's harm or ultimate harm, and if that intervening cause is serious enough, then it is considered superseding, and it cuts off the defendant's liability for additional harm, but not for the harm that he originally caused with his own behavior. Okay. The last element for negligence is damages. That is, that some harm has to, or damage has to befall the plaintiff in order for them to recover. Remember, the plaintiff is responsible for mitigating their damages to the extent that they are able to. There's a case that talks about this in your text out of Iowa. It's the Fuches versus SES Company case. So you can take a look at that. There is additionally some coverage on the collateral source rule. Collateral source just prevents the defendant from avoiding liability or from having to pay for the damages, simply because there are other contributing sources. And when we say sources, we're talking about money sources. So, for example, insurance, other benefits or payments that the plaintiff might collect, those don't excuse the defendant's liability. There is finally in this section a brief discussion of malpractice. Malpractice refers to negligence in a professional business. So you can have medical malpractice, you can have legal malpractice, you can have malpractice in an accounting firm, but it is professional negligence that causes harm or loss to a plaintiff. And that's it for your chapter on negligence. Again, review those elements. Do take a look at the cases in the text because they help to explain how these theories that we covered on negligence apply. I'll see you guys in class.